Hey Jamie, we're here to talk about the Law Society's model pregnancy and parental leave policies. What people need to know is that these are practice management resources which are important for all of us, not just women lawyers or lawyers who might be planning a leave. The policies were prepared as part of the Justicia Project, which is a Canada-wide initiative focused on the retention and advancement of women lawyers. Here in BC, the Justicia Project is championed by the BC Law Society. The project began in BC in 2012 when 17 of the largest regional and national firms signed a Justicia commitment in which they pledged to work together to formulate policies and practice guides to support women lawyers. Although the pregnancy and parental leave policies we're going to talk about originated with Justicia, the reality is both men and women lawyers will take leaves throughout their careers for a variety of reasons, such as medical, educational, leisure, and yes, for pregnancy and parental reasons. And how we manage these leaves, or in the absence of planning, fail to manage them, fundamentally affects both legal practice and client relationships. So right off the top, I just need to say, look at us. Optics are so important. And the optics of the Justicia Project being jointly chaired by both a male and female lawyer is critical because diversity in the profession is a win-win for everyone. And look at you. This picture of you with your baby in lap and advocating for pregnancy and parental leaves, it's a good look, Jamie.
Thanks, Lisa. Bringing a baby into your busy professional life brings a whole new meaning to work-life balance, especially when the baby arrives 6 weeks early, like Morrow did. And parental leave is by no means just a woman's issue anymore. Guys want to be involved parents too, and some actually look forward to taking time from work to care for the baby.
Men being interested in parental leaves is a bit of a generational change, but it's such a good thing. Sharing responsibilities, both at home and at work, can help with work-life balance for everyone. And understanding expectations around leaves and planning for contingencies is just part of how we each best manage our practices. It's therefore not surprising that these issues need to be considered by both lawyers who might be planning a leave, as well as law firm partners who approve policies. So to encourage broader participation in this discussion, we'll need to make our discussions somewhat interactive by including some questions for listeners.
Perfect, because I want to ask all of those tough questions that law firm leaders may be thinking but don't always ask. You know, the ones that question the value of leave policies and why all of us should care about this stuff. Don't get me wrong, I'm a bencher. I do understand the business case for diversity and why it benefits all of us. But those benefits are not always obvious to everyone.
Okay. In this program, let's talk about the practice management risks that leave policies can address, how law firms in the Justicia Project have addressed these issues, and some best practices around managing file transitions and client expectations.
Okay, a good place to start might be a quick look at the business case for the retention and advancement of women lawyers, which the Law Society published in its 2009 report on the retention of women in law. Here it is in a nutshell. Increasing diversity in the legal profession is obviously important for a whole variety of reasons. Supporting the retention and advancement of our women lawyers in particular is important for all of us for three compelling reasons. Fighting for top talent. Law firms want the best and the brightest, and with more than 50% of law school graduates being women lawyers are among that number. Competing for clients who are increasingly demanding diversity in the legal teams they hire. And better decision-making and profitability. Research has shown that having a diversity of perspectives maximizes business performance, increases profitability, and is a risk management tool.
Right, but diversity and inclusion are affected by cultural biases and norms. It's a big ship to turn around. We can't change societal expectations overnight. But what we can do is influence workplace-related biases. The pregnancy and parental leave policies are just one piece of that. These policies are supportive because they help lawyers and law firms manage practices before, during, and after a leave.
Okay, so let's talk about the policies. I want to start by clearing up some terminology, which can be confusing. I've heard of maternity, paternity, pregnancy, and parental leaves. Really, which is it we're talking about?
Well, pregnancy leaves apply only to lawyers who are pregnant or have given birth. Basically, to birth mothers. Parental leave applies to birth mothers and fathers, and also to adopting parents. A similar distinction between pregnancy and parental leaves is made in our employment standards legislation. You know, it's interesting. Maternity leaves were only introduced in Canada in 1971, and paternity leave was only added in 1990. So the concept of leaves is relatively new and still evolving. It's important that we have parental leave policies and not just maternity leave policies, because parental leaves recognize that leaves are important to both men and women and to adopting parents.
I can definitely see why recognition that both men and women who become parents may want or need to take parental leaves is good. But why do law firms need policies at all? Why can't lawyers and their firms just negotiate leave requests on a case-by-case basis according to what suits them?
Because circumstances like that baby in your lap don't always arise when planned or on schedule. Leaves raise practice management risks for both the lawyers who take them and their firms. Anticipating those risks and providing a framework for dealing with them in advance of a leave reduces stress and can manage outcomes with greater certainty. Let's take this out to our listeners and have them consider this from both sides. On the one hand, we have lawyers who want or need to take a leave. What would their concerns be? Would they have financial concerns? Would they be concerned about how a leave will affect their client relationships or the management of their files? And how might taking a leave affect career progression? Financial concerns are likely forefront. Lawyers who want to take a leave will likely be concerned about the financial risks of being away from work. They may also worry about job security and not getting files or clients back when they return to work. And then, of course, with pregnancy and parental leaves, they may also be concerned about the perception of others. Stigma still exists about taking these kind of leaves. Although negative opinions are now rarely expressed openly, perceptions may still exist that because women can choose to have children, lawyers who take these leaves lack a commitment to practicing law. The perception may actually be hardest for men who want to take a parental leave, because taking these leaves and wanting to take these leaves is a generational change too. And of course, when women lawyers return from leave, expectations may still exist about how the distractions of being a parent might affect a lawyer's ability to practice law. Curiously, this is an expectation that apparently does not apply equally to male lawyers who become parents. These concerns and perceptions are all the more reason why we need policies to set expectations and assist with practice management.
On the other hand, risks and concerns also rise for firms when leaves are taken. Leaves may need to be taken, but they're definitely disruptive. So for our listeners again, let's have you consider this from the perspective of the law firm. What risks will your own firm need to address when a lawyer takes a leave? What additional costs can you expect? How will you accomplish file transitions so that they are as seamless as possible for clients? Firms will be concerned about costs and managing files. Who will do the work during the lawyer's leave? Do they hire a short-term contract lawyer? Can they even find one? And what about the disruption for clients, getting to know someone new and worrying about paying for the duplication of time to bring someone else up to speed?
These complications arise whenever a lawyer leaves a law firm, but agreed, they multiply if a lawyer takes a scheduled leave because the client disruption happens all over again when the lawyer is reintegrated back into the practice. To be clear, there are no easy answers to any of this. Each lawyer, each practice area, and each law firm will be different. There is no best way to transition a practice or reintegrate a lawyer back into practice, other than, as recommended in the policies, to think about these issues in advance and have a written transition plan in place. The policies include a useful list of issues that should be addressed in a transition plan. The important piece here is that having policies can depersonalize discussions. They can circumvent unintended biases and address compensation issues in ways that are not personal to the lawyers directly affected. Let's take this out to our listeners again. take a moment now to consider what the advantages might be of a law firm having written policies. The advantages of having written policies might be these. In the absence of a written policy, a lawyer who needs or wants to take a leave may not know how to navigate the issues that will arise in their practice. They may not know how to raise the issues, and they may be uncertain as to how the law firm will respond to their request. These are all practice issues which are potentially fraught with misunderstanding, insufficient consideration, and unintended bias in their resolution. Law firms are encouraged to adopt written pregnancy and parental leave policies because they improve transparency, objectivity, fairness, and consistency in decision-making. They will provide an internal procedure for dealing with requests for leaves and benefits. They promote an acceptance firm-wide that pregnancy and parental leaves are positive practices. They will confirm the firm's commitment to advancing inclusiveness and diversity at the firm to lawyers at the firm, but also to potential recruits and clients. And they'll ensure that the firm complies with its legal obligations, including those under our provincial human rights code.
That all makes a lot of sense. But there's a bottom line cost to all these benefits, isn't there? Our listeners should take a moment now to think of their own firm and consider the costs that might be associated with having written policies, particularly if some form of financial support is provided in those policies. Don't some law firms top up employment insurance benefits and provide for lengthy leaves? What if I work in a small firm where we just can't afford to fund parental leave benefits?
Of course, benefits only make sense if there's a return on investment for funding a leave. As much as lawyers take pride in being professionals, practicing law is still a business. Law firms that financially support lawyers on leave do so as an investment in lawyer retention. The financial benefits included in a policy can be multiple or few. From a practice perspective, what is important here is that the law firm has considered and identified available benefits. In fact, the model policies are just a tool. Law firms come in all shapes and sizes and will have different needs and expectations. The policies are designed simply to assist both lawyers who want to take a leave and the partners who are decision makers by providing a framework to discuss issues that typically arise with a pregnancy or parental leave. The policies are just a guide, but a tremendously useful guide. Financial benefits to lawyers on leave are only one consideration. The practice concerns about managing client transitions and file transfer responsibilities are equally important.
Okay, let's consider the main components of the model policy.
2 model policies are published on the Law Society website. One for associates or lawyers in an employment-type relationship with the firm, and one for partners or lawyers in ownership arrangements with the firm. The policies encourage the inclusion of a commitment statement at the beginning to explain the purpose of the policy. They then deal with pregnancy and parental leave in separate sections and consider issues such as eligibility. That is, do lawyers have to have worked at the firm for a period of time before they are eligible for the leave benefits? How long the leave can be? Whether the firm will pay the lawyer or top up employment insurance benefits during the leave? Whether benefits will be maintained during the leave? And whether lawyers who choose not to return to practice after a leave are required to reimburse the firm for compensation paid during the leave. The final sections in the policy deal with the consequences to a lawyer of taking a leave, such as any expected extension of the years to partnership, what kinds of notice and approval procedures can be put in place, and transitional considerations for both the lawyer and the law firm.
What I find interesting is that the policies provide guidelines and commentary on sensitive issues, such as the length of leaves, whether leaves are paid or unpaid, and in many cases that is whether EI and benefits are topped up, whether lawyers need to be employed for a period of time before being eligible for benefits, and whether compensation should be reimbursed if the lawyer chooses not to return after a leave.
Yes, the policies include information about how the 17 law firms which are involved with the Justicia Project have dealt with these issues.
From looking at the Law Society's website, I see that all of the Justicia law firms are larger firms, and the majority, but not all, top up EI benefits during leaves and provide between 8 and 26 weeks of pregnancy leave. The firms have worked out what makes sense for their practices. Half require compensation to be reimbursed if the lawyer does not return to work, and half have no return to work requirement. Half also have an eligibility requirement for financial benefits in terms of years with the firm, and half do not.
There can really be no single policy that will be right for all firms. What was clear from the Justicia law firms was that views differ on many of these issues. For example, on the issue of whether a lawyer on leave should be eligible for a financial benefit only if they have been with the firm for a period of time before taking a leave, some firms think that an eligibility requirement emphasizes the value of the financial benefit because it rewards years of service to the firm. Others think that an eligibility requirement is punitive because pregnancy can be unexpected, and in practice, they are difficult to administer. Similar considerations play out with reimbursement requirements for lawyers who decide not to return to practice. Lawyers who don't return often find legal work as in-house counsel and can therefore become valued alumni. Therefore, firms that waive top-up reimbursement may do so in part because they see the waiver as an investment in the goodwill of their alumni networks.
Do the policies describe any best practices?
Yes, some. The model policies recommend the recognition of both pregnancy and parental leaves, and that the primary caregiver of a newly adopted child be eligible for the same benefits as a birth parent. The policies also recommend that in determining whether a lawyer's salary should increase after a leave, firms should consider both the length of the leave and the impact of the leave on the lawyer's professional development and growth during the period being considered. But because law firms are all very different, finding best practices was not the primary purpose of the policies. The purpose was to encourage law firms to anticipate and manage leaves with a written policy which provides a framework and a transition toolkit for dealing with the issues arising from a leave from practice. The creation of a written policy itself is the best practice.
I expect that for most lawyers and law firms, the most important discussion will be around a leave transition plan. From experience, I know that a baby can change everything, and both the law firm and the lawyer will have real worries about moving the practice into someone else's hands. Let's go back to our listeners again to consider what a good transition plan should contain. For your law firm, what are the main pain points that you would need to address for both a transitioning lawyer and your law firm? It's difficult to make plans in advance, and we all know that stuff happens. But at least having a discussion about and agreeing upon expectations around issues like client management, salary and career advancement should ease uncertainties for both the lawyer on leave and the law firm. I also like the acknowledgement that the lawyer and law firm have joint responsibilities to ensure the leave is successful.
Yes, the key really is for both the individual lawyers and the law firms to recognize that they have joint responsibilities. Both the lawyer taking the leave and the law firm play a part in making these leaves successful. The transition plan should be in writing and should identify which lawyers will assume file responsibilities, how often, and by what means the lawyers on leave want to remain connected. Example, by email, telephone, or meeting for coffee, and the proposed length of leave, understanding that this may change.
The takeaway then is that creating written policies for pregnancy and parental leave is no different from creating policies for any other type of leave from practice. The same practice management issues arise and need to be addressed. To the extent that the issues can be anticipated and thought through in advance, file transition matters and client expectations can be managed. I know that we can't anticipate everything. Who knew that Morrow would arrive when he did? I can be endlessly curious about who Morrow is and who he may become, but I know this. I don't need to be curious about how my law firm will react to my wanting to take a parental leave. And my law firm doesn't need to be curious about my expectations around such a leave. That kind of curiosity is simply time badly spent by both the lawyer and the law firm. Having a policy provides a framework, to raise the issues in a timely and effective manner. As we all know, decisions made in the absence of a framework can be made without a proper consideration of all applicable issues. Having a policy is also an unequivocal statement by a law firm that the firm recognizes the issues inherent in any leave and will be supportive of its lawyers. The optics of that statement alone cannot be underestimated.
On behalf of both Jamie and me, thank you for participating in this program. We hope that the model policies will be used as a guide for discussing the practice issues that arise with these leaves.